Hey guys, welcome to my murder criticisms and reforms. This is for voluntary manslaughter as well as murder, so the defense is as well as murder. This is only the murder answer, and as always the link is in the description to download this specific answer if you don't want to hear me go through it. So here's the question that you'll be faced with in the exam, potentially. Despite some recent reforms, there are still some criticisms to be made on the current law on murder and voluntary manslaughter. Consider relevant criticisms of the law and suggest any reforms that may be appropriate. So it's 25 mark. This is generally a sound murder answer. It'll get you full marks for the murder aspect, but you'd have to add the reforms and criticisms for diminished responsibility and loss of control yourself. So let's start. In 2006, the Law Commission published a report, Murder, Manslaughter, Infanticide. In its general comments, the report described the law on murder as a rickety structure set upon shaky foundations. It states that the law is unsatisfactory, as some elements have remained unaltered since the 17th century, and others have changed to the point that they can no longer be stated with any certainty or clarity. It gives a general introduction and states what the Law Commission's report says. Then it goes straight into the criticisms. The mandatory life sentence for murder has come under much scrutiny. The reason for this is that the judge has no discretion regarding sentencing. They must impose a life sentence regardless of motive. For example, a serial killer such as Sutcliffe, who is clearly a danger to society, will be given the same sentence as mercy killers such as Francis Inglis, who pose no threat to public. So this goes back to the sentencing, and that judges have a mandatory sentence that they have to go to. A redeeming factor of this life sentence is the tariff system. In each case, the judge will impose a life sentence, but will then state the minimum number of years that you will see. I think that says we'll see. This allows judges to differentiate between those dangerous to society and those that are not. For example, Peter Sutcliffe was given a whole lifetime tariff, whereas Francis Inglis was given a tariff of 9 years minimum. So this just goes back to the point that was raised and states a redeeming factor basically. With regards to reform, the Law Commission report, section 304 of 2006, suggests that the offence of murder should be separated into two offences, first and second degree murder. First degree murder would cover cases where the defendant intended to kill, and it would also cover cases where the defendant caused serious harm, so GBH, and was aware that his or her conduct posed a serious risk of death. Cases in which the defendant intended to do serious harm, GBH, but was not aware that there was a serious risk of death, would be second degree murder. The mandatory sentence would only apply to first degree murder, and sentencing for the second degree murder would be left to discretion of the judge. This reform would not solve the issue of imposing harsh sentences for mercy killers, as they still intend to kill and would therefore be convicted of first degree murder, which still would carry a mandatory life sentence. A more appropriate reform may be to abolish the mandatory life sentence, and instead allow complete discretion regarding sentences for murder. This would allow judges to impose life sentences, Sutcliffe, or discretionary sentences, Inglis, where appropriate. So this goes back to the points that were raised in the second paragraph, back to the two killers. The mens rea of murder has also been criticised as being unsatisfactory. Under the present law, the defendant is guilty if he intends GBH and the victim dies. In some cases, the defendant may not realise death may occur, yet he is just as guilty of murder as someone whose main aim is to kill his victim. This means that the defendant can be guilty for what he does not foresee. Both the Law Commission report and the judges criticise this rule. In the case of Cunningham, Lord Davies states that he thought the mens rea of murder should be limited to an intention to kill. It has been suggested that this element of constructive intent communicates the message that if the defendant intends to do serious harm, they should know it could lead to death. This was the case in Blau, a case in which the defendant intended to do serious harm but caused death. This rule ensures that the defendant takes responsibilities for the consequences of his conduct. There's quite a lot of criticisms here for the first page, and quite a few reforms for murder. The last aspect would be the Law Commission's report proposed that this should be solved by splitting murder into 2 offences. Proposal discussed earlier as a potential reform for mandatory life. This reform would resolve the issue of constructive intent, as the mens rea and actus reus would match. This would allow the judge to differentiate between people who foresee death, first-degree murder, and those who do not second-degree. By imposing different sentences, this reform is appropriate, as people would therefore be punished for what they foresee. That would be a general idea of the first aspect, murder, what you have to write. Now, the question also asks for voluntary manslaughter. That would be the defences of loss of control and diminished responsibility. Now, for loss of control, it is essential that you'd put the reform of sexual infidelity and revenge in regards to R.V. Clinton, because R.V. Clinton is now required in the exam because it came into place last year. If you mention, so you have to mention that for loss of control reforms. For diminished responsibility, you can mention the fact that there was reforms in the Coroner's Justice Act 2009. The definition is clear now of mental functioning as substantially impaired mental responsibility. There's loads of stuff you could write, but what I'd do is I'd write 3 maybe 3 or 4 criticisms, so 2 each, or maybe 3 each, and then a couple of reforms, like 2 reforms for each one. That would make sense for the examiner, as you've written a lot about murder already. So as always, I'll post this in for you to download below. You'd have to add the obvious diminished responsibility and loss of control reforms and criticisms, but that's about it. Hope you found this useful, and see you next time.